Hey guys, I'm Ronit. So this video is about the law CIA, which was given by Chirag. So the case which I took for the CIA is uh, Lalman Shukla versus Gauri Datt. Yes, in 1930. Yeah. Before going to this case, let me tell you about an example. See, let us think that this is a swimming pool, and here I announce a reward that whoever crosses the swimming pool within 10 minutes, I'll give them 10k, rupees 10k as a reward. Then, two friends, Rohit and Rahul, they were playing beside the swimming pool. Rohit pushed Rahul to the swimming pool. Right. So Rahul, to save his own life, he crosses the swimming pool within 5 minutes, and they don't know about the offer which I gave them. That whoever crosses the pool get the 10k. That offer they don't know. Right. Then they get to know about the offer, and then they came to me and asked me to give them 10k rupees. So in this case, should I give them 10k rupees? 10k rupees. This we'll get the answer from the case Lalman Shukla versus Gauri. So let us get to know the characteristics in this case. They are Lalman Shukla and Gauri. Lalman Shukla is also the servant of Gauri. In this case, plaintiff is Lalman Shukla and Gauri is the defendant. So Lalman Shukla is also a servant of Gauri. Right. So one day, Gauri's nephew ran away from the house. So Gauri ordered Lalman Shukla to go and find and track his nephew and get him back home. So Lalman Shukla went in search of his nephew. While he was searching his nephew, Gauri announced a reward of 501 rupees. Whoever find his nephew will get 501 rupees as a reward. Then after some days, Lalman Shukla found his nephew and brought back to his house and gave it to him. After some days, Lalman Shukla got to know about the reward and wanted to claim the reward. Right. But Gauri was not given. Okay. So this came to the court. So we'll see. So what will happen? Right. So we'll see what are the issues raised in this case. Right. So the main issues which were raised in this case were as follows: whether Lalman Shukla was entitled to get the reward from Gauri for tracing the missing boy, which means his nephew. Right? Whether there was a valid acceptance of the offer made by the plaintiff, which means Lalman Shukla. Right? Whether there exists a contract between, whether the situation amounts to the contract between the two. These were the issues raised in the case. So we'll see the arguments faced on the behalf of the plaintiff, which means Lalman Shukla. So the plaintiff Lalman Shukla strongly affirmed that the very performance of him finding the missing boy was sufficient enough for him to entitle the reward. Since according to the Gauri's condition, whoever find the lost boy and brought him back would get the reward. Therefore, as per the condition of the defendant, the plaintiff had raised the boy and brought him back. Right. He stated that it is not important to have a prior knowledge about the reward, especially under the circumstance. He also emphasized the fact that Section 8 of the Act IACA 1870, the Indian Contract Act of 1872, states that the performance of the act or the acceptance of any consideration of a proposal is an acceptance of the proposal. Right. And in the present case, the condition as stated by the defendant Gauri was to find the missing child, which is his nephew, to be rewarded 501 rupees. He stated that it is immaterial that the person who has performed the act must had the knowledge of the condition to claim the refund. Right. Now we'll see the arguments behalf of the respondent, which means Gauri. Right. The defendant are ascertained that and strongly argued that the plaintiff Lalman Shukla was not aware of the offer and had no knowledge about the offer before finding the defendant's nephew. Right. So, an offer without knowledge of the offeree or the promise cannot be accepted, and also there is no such possibility of the plaintiff to accept the offer without even knowing about it. Gauri argued that accordingly to Section 2 of Indian Contract Act of 1872, when one person signifies to other his willingness to do or to abstain from the doing of anything, a view of obtaining the assent of the other to such act or existence, he is said to be the proposal. Right. This is under Section 2, bracket A. Further under Section 2B, when says that when the person whom the proposal is made signifies his assent thereto, the person is said to be accepted. The proposal, when accepted, becomes a promise. Right. Therefore, the defendant contend that assent was essential to create the contract between the both parties. This means that before accepting the offer, the offeree must have complete knowledge about the facts to give assent or approval. But in this particular case, the plaintiff was completely unaware of the reward which was associated with it, and the plaintiff was merely doing his duty. Right? Therefore, according to Section 2 of H of the Indian Contract Act, since there was no acceptance, there is no agreement and can be enforceable by law. So, according to the defendant Gauri, that Lalman Shukla was not entitled to get the reward and hence couldn't claim it. So, what do you think the judgment is? Then here comes the judgment by the court. In the said case, the petitioners appealed against the respondent Gauri and was dismissed by the court. After analyzing all the facts of the case, the Honorable High Court held that for creating or entering into a valid contract, there has to be a knowledge and assent to the offeree made by the proposer. Here, the plaintiff did not know that the reward before performing this act. He only came to know about it later. Right? In which case, there is no possibility of accepting the offer. Hence, there was no contract. Therefore, Lalman Shukla was not entitled to get or claim the reward. The judge retired the plaintiff was fulfilling his obligation as a servant of tracking the missing boy, which was part of his duty. Therefore, the plaintiff's suit against the defendant was completely dismissed by the court. Yeah, this is the case of Lalman Shukla versus Gauri.